Apple's winning.
Can conduct meetings.
And there is no option for people who would like to go to a different place. So that, to my mind, is another reason why the primary market is not a source of competitive constraint for Apple's conduct meetings.
Mr. Dorn. Thank you, Your Honor. First of all, I guess I'll begin where the court did with Mr. Bornstein, which is the single market.
Chat, listen. I am looking at the Zoom right now. It is saying, warning, any recording of court proceeding held by video or teleconference, including screenshots or other visual copies of a hearing, is absolutely prohibited. But do you not realize I'm not showing it?
This case does not fit the narrow exceptions created by Kodak and Intel. There are two fundamental differences. In both of those cases, the plaintiffs were locked in to dealing only with Kodak and using Kodak parts exclusively and using Kodak repair personnel exclusively. And in Newcal, there was an extension of service contracts after there had been those plaintiffs had been locked in to dealing exclusively with Newcal. So first of all, to fit the Kodak or Newcal exception to the general rule that there's no such thing as a single brand market in the antitrust context, the developer here in this case must be locked in. But Your Honor obviously has the record well in hand and knows that there are many channels.
I'm not gonna get sued. Shut up, everybody. Holy shit.
And while Mr. Bornstein referenced the 63 million person figure, in that same paragraph 3 of Mr. Sweeney's declaration, he explains that on 10% of the average daily players of Fortnite are using iOS devices, meaning that 90% on any average day, 90% of the people who are playing Fortnite are using a device other than iOS. We also know, Your Honor, that Fortnite is based on, and Epic's business model is premised on, interchangeability of platforms. They urge people to use various platforms. And while Mr. Bornstein has asserted that not everyone has separate, or multiple devices, there's no evidence in the record on that. And instead, when we talk about those who have access Fortnite by one device, that does not tell us how many people are actually regular players. And there we see it as simply 10%. So first of all, Your Honor, there's substantial interchangeability. Epic uses that as one of its basic promotional properties, that people can go on different devices and continue to play, that they can make purchases on one device and go to another device and continue to use it. And 90% of the daily players are using other devices. Secondly,
Please, fuck.
both Kodak and Newcal involved once the person was locked in, there was an undisclosed change of terms that impacted the plaintiffs in a negative way. In Kodak, the exclusivity of dealing exclusively with Kodak parts was interposed after the contract ended. In Newcal, the extension of the service contracts occurred after they were already locked in with Newcal. And Epic has cited to Judge Oreck's district decision in the Teradata case, generally. But at page 16, Judge Oreck also comments on Kodak. And he says the Supreme Court in Kodak adopted a limited exception for a single aftermarket product in which customers do not agree on restrictions that were undisclosed at the time of the purchase.
They'll come back. They'll come back. Don't worry, guys. They'll come back.
There is no question here that any disagreement that Epic has with the terms of the Apple contract with Epic, not with consumers, but with the distributor.
Okay, I'll turn off my mic. I'm sorry.
Where is the competition? Where does that 30% number come from? Why, as I asked before, why isn't it 10 or 15 or 20 or 30? There doesn't seem to be competition, and that's what we're concerned about. Is competition, not Epic, not any particular developer. Competition.
Your Honor, two responses. First of all, to your specific question, the test for monopoly power is whether the alleged monopolist can increase prices by decreasing output. And as for monopoly maintenance claims, there needs to be some indication of anti-competitive conduct that is used to maintain and sustain a monopoly. Here, Apple established a business model back in 2008 when it first launched the App Store with 500 apps. Since that time, and in 2011, when it began in-app payments for in-app purchases, it set its commission at 30%. Neither of those things have changed since 2008, except the output has exploded. It has gone from 500 apps in 2008 to 1.8 million today. The commission has never been raised. In fact, it has actually decreased on subscriptions after 1 year, and that is something that doesn't involve Epic, Your Honor, but it does involve other participants in the App Store. That has been decreased to 15%. As Your Honor has already noted, 84% of apps are absolutely free, and Apple recognizes nothing from those. And as to the effective commission, if you will, people were willing to pay, and Apple marketed when it obviously there was no whiff of market power, be it in video games, which, as Your Honors noted, there's profound competition in still today, or any other element of the market. Apple had no market power when it set 30%. We would suggest it still does not have market power in app distribution because there's so much competition in it. But what has occurred since that first app or first iPhone is that the devices have become profoundly more sophisticated. Apple's, they have provided profoundly more opportunities for distribution and also for higher tech apps, if you will. So as our experts testify, the effective commission has actually gone down over these years. And so, Your Honor, there is the test, if you will, for whether or not there is competition would suggest that there is competition. The Epic has identified no anti-competitive conduct by Apple. They use the term, but they don't cite any facts. Their expert doesn't even use the term. And on the pro-competitive side of the scale, the evidence is overwhelming.
Right, I interrupted you. You can go back to what you were arguing.
Oh, thank you, Your Honor. And by the way, on that, Your Honor, I would suggest that when Epic suggests that it doesn't challenge the 30% commission, that's exactly what it challenges. Epic, and I realize we aren't to the tying claim yet, but it's not credible that Epic has a problem with IAP as a technical element of the business model that Epic has chosen to implement. Your Honor, finally, in terms of what market this court should be looking at for purposes of today's motion, the only evidence in front of this court relates to Fortnite and relates to Epic. Therefore, when we are talking about what is the relevant market for this motion, the only evidence that's been offered this court relates to Epic and Fortnite. The court has no other basis from which to evaluate the competition in the marketplace. In fact, the only other product identified is a reference to Pokemon by Mr. Evans, or Dr. Evans, as he attempts to distinguish.
Yo guys, can you get me back up to 1,000, please? I lost subs because I accidentally muted the video. Can you get me back up to 1,000?
Your Honor made the excellent point that the Nintendo Switch is about 40 by 9 inches. Microsoft offers tablets that are less than gaming Fortnite on GeForce Now only. There's almost 250 million gaming consoles out there as well. And common sense tells us that a 12-year-old Fortnite player would prefer a big screen and a large control pad rather than playing with their thumbs on the bus. So, Your Honor, this notion that because a console is not portable, first of all, that's wrong as a factual matter. There are many portable options. And second of all, Epic has actually not put any evidence in the record that says that there is a portion of the population who is completely committed to playing solely on mobile. There's only broad assertions in that regard. So in terms of conducting the test required under the Sherman Act in looking at reasonable substitutes, rough equivalents, and reasonably interchangeable distribution channels, which is what we're talking about here, not consumer use, but distribution channels for Epic, they have not shown that any of the different platforms this court has identified are outside of the relevant market. They all must be included in the relevant market.
All right, so Mr. Bornstein, Mr. Doran made the point that plaintiffs were not locked in. 90% of their base has access. Do you agree that they're not locked in? You're muted, Mr. Bornstein.
I was being so respectful of Mr. Doran, I kept myself on mute, Your Honor. I do not agree with that point. I'll make two observations about it. First, it's not the law. This idea that you are required to have lock-in, you'll notice it's not in Apple's brief. There's no discussion, in fact, of the NewCal factors at all that we just heard from Mr. Doran in Apple's brief. This is a new argument, and it is wrong. There are 4 factors in NewCal. The one that is closest to this lock-in idea is whether there are switching costs and information costs in the primary market that impose competitive discipline in the aftermarket. We've talked about that at length. I won't go through it again, but to say that there needs to be lock-in.
He was arguing a point that was made by Judge Alsop. So I just, let's get to, and I can read the cases as well as you all can.
Better.
So the question I have from you, just in terms of what's in front of the court, relates to the issue of lock-in.
Sure. So the evidence in the record, Your Honor, is that 63% of people who play Fortnite on iOS play it only on iOS. That's in Mr. Sweeney's declaration. There is evidence to that effect. Secondly, there are approximately 1 billion people who have iOS devices. And there is, those individuals we have shown are locked in, to use the term loosely, through the information and switching costs that I described to that device. And therefore, we can't reach those people through distribution unless those people also have some other device.
Yeah, so you want access to Apple's customer base. That doesn't necessarily mean you're locked in, given that it's, 10% of your user base?
It's not 10% of the user base. The information that Mr. Doran was citing was daily active users, just to make sure we've got the right stat. But the issue, Your Honor, is if you step back and ask the question that is relevant to the antitrust analysis, which is there competitive discipline imposed on Apple by the existence of these other distribution options for apps generally? Or if you want to get specific and talk about games, or even more specific and talk about Epic, although I would submit you shouldn't get that specific in assessing the market.
Well, but you do agree that that's what I have in front of me now. It may not be what I have in front of me at a trial, but in terms of what I have in front of me now, it is this game market.
I don't agree with that, Your Honor. What the court has in front of it right now in Dr. Evans' declaration is a discussion of apps more generally. We don't have a gaming app market that's at issue here. We have an app distribution market on the iPhone. And to get to the point about whether
the 90% or the 10% plays in here. In order for Apple to face competitive discipline from the availability of these other distribution channels, it would mean that there need to be a meaningful number of people or developers who'd be willing to give up the platform if Apple raises its price. And we know that that's not the case. Developers are not going to sacrifice 1 billion users for the opportunity to reach 1 billion users if there's a slight increase in the price or the other terms that Apple charges. And a great example of, I apologize, Your Honor.
Finish your sentence. Then
Sure. I was just going to say a great example is the one that Mr. Doran gave with respect to users. Yes, it's true a 12-year-old who plays Fortnite would probably rather be using a big controller on a big screen, and yet we see that 63% of those users play only on iOS. That to me is powerful evidence of the fact that these people are actually, I don't want to say locked in because it's not the right test, but are actually committed to this platform and don't have the opportunity and aren't willing to spend the money to buy alternative platforms to use. I think that's powerful evidence in our favor, Your Honor.
The I have a corollary on that. Mr. Doran indicated that you haven't identified any anti-competitive act, and by your statement, I suspect you agree with that, and that is because you're saying that hypothetically they could change the rate, but in fact they haven't changed the rate. So is the anti-competitive act that they won't let someone else on? Is that what you're arguing, or what is the act that he says that Epic's not identified?
Yes, in the app distribution market, the anti-competitive acts, plural, are the technical restrictions that are imposed and the contractual restrictions that are imposed that prevent alternative distribution from being available on iOS. It's that simple. Epic right now today would like to have its own store to distribute apps on iOS. It can't because Apple has prohibited it. Flat forbid. That is the anti-competitive act at issue.
The courts have sometimes indicated that licensing restrictions, which is what those are do not constitute antitrust actions. And there seems to be great disagreement with the licensing provisions at issue here. What's your response?
I would say, Your Honor, there is no blanket exclusion to the antitrust laws for licensing. There are a variety of cases that analyze the use of patents, for example, and whether or not they are misused or whether, and in a way that is in violation of the antitrust laws. There are situations in which...
When that happens, aren't they coupled with some other act?
And here, Your Honor, I would say they are. I'm not sure, frankly, that is a requirement, but here I think it is the case.
Well, do you have law to support that notion? Because there is law to support the notion that disputes over licensing is insufficient.
Your Honor, I think in terms of whether or not the court is suggesting that a dispute over licensing is per se exempt from the antitrust law, I would submit that is not correct. There is, if that were the case, for example, the Ninth Circuit's decision in Qualcomm recently would have come out, it would have been much easier to write for the court since the issue there turned on patent licensing. There was instead an in-depth analysis of the nature of the restraints and the effects. And the court did not simply excuse the conduct at issue from antitrust scrutiny because it related to licensing. There is also Federal Circuit case law on the subject, and I am temporarily blanking on the name of the case because I hadn't considered the issue since it wasn't raised in Apple's brief that licensing was somehow excused completely from the antitrust laws. We can certainly submit supplemental authority if that would be useful for Your Honor.
No, it's just a question I had as I was reading the cases. Mr. Doran, any comment?
Just a couple, Your Honor. First of all, in our opposition, we do, in fact, of course, speak to a party's right to safeguard its intellectual property, and we agree with Your Honor's observation that that is not an antitrust violation. I would also note, Your Honor, that counsel for Epic acknowledged that what Epic wants to do here is open its own store within the App Store. That's really what this litigation is about. That's really its objective here. And that takes us back to Apple's fundamental business model. And frankly, the contention by Epic, which it repeats, but never proves, that Epic's commitment to safety, security, and the privacy of its user information is a pretext. And that is essentially an indictment of Apple's entire business model, which has been committed to the safety, security, and privacy of its users since day one. And it also ignores the record in this matter, such as at Schmalensee paragraph 36, he notes that less than 1% of malware attacks occur within the App Store. And that is because, Your Honor, Apple safeguards the App Store and safeguards the iOS operating system to assure that its users are safe and secure when they come into this environment. Now, Epic would like Apple to let it into the App Store and would like to let Epic set up a competing store within Apple's own store. That is a fundamental disagreement with the way Apple has chosen to do business. But Apple's business model has been consistent throughout its existence. This is the way it has chosen to set up its model, and its trademark is to safeguard its users. And it has concluded that through app review and through maintaining a system where it closely controls what is on iOS, that is the best way to safeguard its users, and that's what keeps it competitive in a very competitive marketplace. And the statistics bear out that Apple's efforts have been effective. Secondly, Your Honor, counsel commented that the court should look at the 63% figure rather than the 10% figure. Your Honor, I would suggest that Fortnite has the data, and they could have put forward very precise information for this court had they so chosen. The 63% figure states that 63% of Fortnite users on iOS access Fortnite only on iOS. That does not tell us how many actively play. That just tells us that if we look at everyone who has ever opened Fortnite on an iOS platform, that they didn't use others. Perhaps they looked and lost interest. We don't know. There's no information offered. The one relevant comparative statistic, the one that tells us how Apple compares to its competition in the marketplace, is in the line before that, which states that from the time Fortnite was launched on iOS through August 13, 2020, nearly, so less than 10% of Fortnite's average daily players used an iOS platform. There is huge market competition. The market is broad, and Apple does its best to compete. But we know, and Mr. Schmid's declaration is the one piece of evidence in this case regarding the market discipline or specific testimony. And Mr. Schmid testified at paragraphs 8 and 18 in his declaration that he has been repeatedly told by Epic that Apple is the smallest piece of the pie, and that Apple has to hit Epic's deadlines or they'll proceed without them. No one in any of the Epic declarations has denied that. They too have said, we have told them they need to hit the mark or we would leave them behind and only bring them in later.
I think that's what the numbers bear out, right? Fortnite, where Epic has advised the court, they've got 350 million users, 116 million have registered their device, so somehow linked in iOS. 10% of their 25 million daily users
2.5 million, Your Honor. Oh, I'm sorry. I apologize, Your Honor. 10% of the 25. Understood.
Right. 10% of the 25, which gives you about 2.5 million. Of that 2.5 million, maybe, I guess, 63% only linked to their iDevice. So 10% of 63 is about 6%.
I'd agree that that's a reasonable alternative reading of this paragraph. Yes, Your Honor. About 6% of
now, 6% is still about 1.575 million people, not an insignificant number.
And Your Honor, as I
devices, I would say, right? 6% is small for Epic, but it's still 1.575 million people.
And yet, Your Honor, it's remember, we define the market looking at the product, not the consumer. And the product here are channels of distribution for Fortnite. And what this tells us is, and what the court has already noted, is there are many channels of distribution for Fortnite. And even if Your Honor's interpretation that you just offered is correct, and as I said, I think it's a reasonable interpretation of what's written here, nonetheless, that does not mean that these users, should they want it, can't access Fortnite through other channels. But again, for purposes of this antitrust analysis, the question is whether or not Fortnite has alternative channels. And additionally, under the antitrust laws, Fortnite is not entitled to necessarily access to every single person on the globe. They only need to have reasonable distribution alternatives available, and they have that in spades.
Okay.
Your Honor, if I may address the numbers here.
Sure.
Thank you. I note that Mr. Doran did not endorse that particular interpretation of the numbers and said, well, it's a reasonable reading. I submit that's because he probably understands that's not actually the right number here. The 63% is 63% of the 116 million people who have downloaded Fortnite onto a device or have otherwise logged into Fortnite. So we're talking about 71 million people or thereabouts based on my rough math, not 1.75 million or whatever 63% of 2.5 million is.
I wasn't saying the 63% were those linked. I was taking 10% of that because your declarations indicated that only 10% of your users are daily users. I was looking at daily usage numbers.
Yeah, it's 10% of the daily active users recently have been iOS users. That's the right calculation. But of the total number of users who are reachable and who have signed into Fortnite, we're talking about 71 million people who sign in only through this way. And again, rather than quibble too much with the numbers, the issue really is this the right framework in which to look at whether there is competitive discipline imposed here? And for all the reasons that I've talked about in terms of the non-substitutability of these alternative distribution channels, it is very much our view that the possibility of playing a game on an Xbox or on a PlayStation doesn't stop Apple from imposing whatever rate it wants, or at least a small but significant non-transitory increase in price on the distribution of apps on the iPhone. Ultimately, I think it comes down to the sort of relatively pithy point that's made in one of the declarations that you can't carry a PlayStation in your pocket. And you can't use.
You keep forgetting other devices, right?
You can't.
Forgetting Switch. I went online yesterday, and at least in the Bay Area, you can't get a Switch anywhere. You can't get it at Best Buy. You can't get it on Amazon for at least a week. You can't get these devices. You can't get it at Target. You can't get them anywhere.
But doesn't that make the point?
As if, and perhaps it's because everybody's stuck at home.
Well,
but if they're stuck at home, they're probably downloading it on their TVs.
Yeah, but doesn't it make the point, Your Honor, that you can't get these devices? There are 1 billion iOS devices out there. The possibility that some people might have the money to buy themselves an alternative gaming device, if they can find it, does not impose a competitive discipline on Apple with its billion users. That's really the point. It's just not a substitute for being able to reach the iOS users that there might be some other channels. And I don't want to lose sight of the fact that we're not talking just about games here, right? We're talking about an app market more generally.
I know that that's how you want to frame the issue. I'm not convinced that you have.
I understand that that's the court's perspective. I would just urge the court to take a look at what Dr. Evans has to say about the definition of the market on that point.
I do, and I think this is going to be a fascinating trial, frankly, because each of these experts makes a compelling argument. And like I said, there's great debate in the industry. But it's complicated, because if we look at this plaintiff and this industry, walled gardens have existed for decades, right? Nintendo has had a walled garden. Sony has had a walled garden. Microsoft has had a walled garden. And so in this particular industry, what Apple's doing is not much different. Now, that's not to say that what they're doing in the general developer market is not different. They created a platform. They have some competition, but we're, as we frequently are in the Northern District of California, we're in a new world. It's they don't call this the Wild West for nothing. I mean, we frequently see these kinds of new issues, especially in technology. But this particular market has frequently had walled gardens. And it's hard to ignore the economics of the industry, which is what you're asking me to do.
Well, I agree with the very first thing Your Honor said, which is that this is complicated for sure. I would respectfully disagree with the last point Your Honor made, that I'm asking the court to disregard the economics of the market in the following respect. For example,
I'm being very specific, which is that you're asking me to ignore the economics of the gaming industry.
Understood, Your Honor, and I'll try and address that very specifically. Mr. Doran made the point, and I agree with him, that just looking at the 30% is not capturing the economics of the transaction. That is just the rate. There are a number of other economic factors and terms that play in. So take a look, for example, at Microsoft and the Sony PlayStation. The economics of the transactions between those companies and the developers are entirely different, and the users are entirely different. The consoles are sold, for example, at a loss. So 30% there is very different from 30% here. I submit the court does need to look at the entirety of the economic situation in each place. And I would be remiss if I didn't make the point just one more time, that I think that restricting the analysis here to games is looking at it from the perspective of the plaintiff, when the way that one defines a market is to look at it from the perspective of the monopolist or the hypothetical monopolist. That's the test. It's not, is this particular plaintiff in a position to find alternatives? It's, is the monopolist in a position, as Mr. Doran said, to profitably raise prices above a competitive level? And that needs to be the focus, I would submit.
Well, plaintiffs always want me to define relevant markets as narrowly as possible. It helps their case. And defendants always want me to define markets as broad as possible, because let's move to section 1. I can tell you I'm not particularly persuaded with the Section 1 proffer, Mr. Bornstein. 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 With the Section 1 proffer, Mr. Bornstein.
And they are required to use the Tide product, the IAP. Jefferson Parish, which is the seminal Supreme Court tying case, is a good example of this. The tie there was medical operations tied to anesthesia. And the court found that there was a tie in that case, where people who had operations at this hospital were required to use a particular practice of anesthesiologists. Well, there are medical operations that people undergo where they don't need anesthesia. Right? The fact that sometimes people engage in the tying market without also needing what's in the Tide market, that doesn't make it any less of a tie. For people who need both products, there is a contractual requirement. That was true there. That is true here. And
Sure.
I'm sorry, Your Honor. Did you call on me?
I did.
Thank you. So Epic essentially declares IAB to be a separate product from the App Store, but without any evidence that it is in fact a standalone product. IAP is simply the function within the App Store that administers the collection of a commission when Apple is due that commission on paid apps and in-app purchases. It's never been marketed or sold separately. Epic has offered no evidence of there being a separate demand for IAP specifically as a product. And it's not at all like PayPal or Stripe in that it is an integrated element of the App Store designed specifically, again, to collect Apple's commission and distribute payment in as seamless a way as possible for the consumer, the developer, and Apple. In fact, Apple outsources the actual administrative step of the payment processing. This, Your Honor, the closest case we could find to this specific fact pattern was the Rick Mick Enterprises case out of the Ninth Circuit, which is pretty darn close because there the Ninth Circuit addressed the question of whether a payment processing function, which was a required component of a product, could form the basis for a tying claim, and the court there held it could not. And specifically, the Ninth Circuit stated that where the challenged aggregation is an essential ingredient of the system's formula for success, there is but a single product and no tie exists as a matter of law. And here, Your Honor, IAP is, again, a function within the App Store, within the iPhone, is an essential ingredient of Apple's formula for success. And it has been there, again, since the beginning as an integrated part of Apple's offerings.
Yeah, I don't, Mr. Bornstein, I just don't see this as a separate and distinct product. I see it as a very creative way to get it to 30%.
Well, may I take a shot at addressing that, Your Honor?
You may.
Okay, I appreciate that. Just to respond to the observations that Mr. Doran said about this being an integrated set of functions and an integrated set of transactions, that exact argument, was presented by the defendants in Jefferson Parish in the Supreme Court. What they said, and I'm going to quote how the Supreme Court described the argument there. They argued, and I quote, that the package does not involve a tying arrangement at all. They are merely providing a functionally integrated.
$5, $9, and $20. Like a brother.
Just I'm inviting Doggo.
$5.
Package of services. And what did the Supreme Court say? They said, no, that doesn't work because, quote, our cases indicate that the answer to the question whether one or two products are involved turns not on the functional relation between them, but rather on the character of the demand for the two items. And Judge Oreck says the same thing in Teradata, the same case that Mr. Doran referred to us earlier. The defendant there, SAP, said, well, we have an integrated software product. And the court said, well, I'm going to look and see if there is separate demand. The fact that you go ahead and you integrate these two things doesn't insulate you from review under the antitrust laws as to whether what you have done in integrating them is a tie. And here, the supposed integration is not a technical integration. It is a contractual tie of the two separate products. And so the thing the court needs to do is to look at whether there is separate demand. That is the right test. And it looked like Your Honor was going to say something, so I don't want to.
So Apple Pay. Seems to be, to me, much more like PayPal than when I'm in an app and I purchase something and it's tied to my credit card, and so it just gets charged to my credit card, and Apple takes its cut and gives the developer their cut. I don't see how that's, and I don't see how the transaction of divvying up the payment is a separate and distinct product.
So to address the first point, if I'm getting an Uber, right, my credit card is in there already, and I get my Uber, and it seamlessly goes through, and I don't have to do anything else. It's just like IAP in that respect, except Uber is not required to use Apple services. Why? Because Apple doesn't make it. We can speculate about why they have chosen or not chosen to extend the tie that far, but they have chosen not to. As to whether it's a separate product, this is something Dr. Evans does address, Your Honor. There is, in the first instance, a transaction between a consumer who is looking to obtain an app and the developer in the App Store, facilitated by Apple, to obtain the app and get it downloaded onto the device. That is a transaction that Apple facilitates through the store because Apple requires everyone to go through the store. Whether a year from now that person wants to upgrade their fitness app from the free version to the premium version and get more data about their daily run, or whether somebody wants to upgrade their subscription to a particular periodical or news source, that is a separate decision made at a separate point in time, which is a transaction that occurs between the user and the developer of the app. So to take Fortnite as an example, if a Fortnite player a year from now, after downloading the app onto, well, it can't right now on the iPhone, but after downloading the app onto his or her device, wants to make a purchase in the game, that is a relationship that the app has built with the consumer. It should be run by the app and the consumer, the customer service, the refunds. They should all be managed between the developer and the consumer, instead of having Apple intermediate down the line in this entirely separate transaction.
All right, a response.
Your Honor, first of all, Jefferson Parish and Teradata both did deal with separate products and products that were offered separately. And here, IAP has never been offered separately. It's never stood alone as a product. It's never been offered as a product, and there's no evidence of a separate demand in the market for it. So it's utterly distinct from the tying of a second product to a first. Rick Mick is the case that really is on point here, Your Honor. That was a motion to dismiss case where the court held that the inclusion of a payment process within a product was not a separate product. And that's exactly what we have here. And just as the court could find that on the motion to dismiss stage there, so too this court can conclude that this is not a separate product. We talk about, or Mr. Bornstein finished up by talking about the timing of the transactions, but Mr. Schmalensky addressed that directly in paragraph 6 and paragraph 59 of his declaration, where he said there's no economic basis to distinguish between in terms of evaluating whether something is a product, a separate product or not, from an initial transaction to a subsequent one. At the end of the day, Your Honor, I'll take no more time on this because this is simply an element of the App Store, which is an element of the iPhone. It's a fully integrated product. It is not a separate product with a separate demand in a separate market.
Okay.
Your Honor, may I be heard on the subject of separate demand, which has been raised a few times now?
All right, briefly.
Sure. I will just point out we have in our papers, I can refer the court to it, extensive evidence of separate demand for the payment processing checkout function from the App Store. There are, first of all, the apps that Apple doesn't require it to be used for, like Uber and other physical apps. There are the other app stores we've identified on Android, like Aptoid and SlideMe and others, and Epic Games itself that doesn't require the use of an affiliated IAP. Those are in footnote 45 of the reply declaration from Dr. Evans. There is evidence that when Epic did the hot fix, over 50% of people chose to use direct pay. There was user demand for that product, separate from Apple IAP. And Apple disclosed in its papers for the first time that there have been thousands of instances in which developers have attempted to introduce a separate payment processing service in an app, and Apple has rejected it. There's clearly demand from both developers and users for something separate here.
On that last point, separate from the antitrust specifically, you've mentioned, Mr. Dorn, multiple times that, and it was my understanding that Apple uses third parties to address the payment function. One, am I correct in that? And two, does Apple use, or would they use other providers, let's say such as PayPal, if PayPal gave you your 30%?
No, Your Honor, because IAP involves a number of other elements. For example, IAP deals with foreign taxes, it deals with foreign withholdings for the developers. And as to the users, when a transaction goes through the App Store, then Apple's commitment to the safety, security, and privacy of its members kicks in. And for example, the payment information provided to Apple by users is never shared with the developer, and there are parental controls in place so that parents have an opportunity to make sure that their kids aren't buying too many skins or V-Bucks on Fortnite or whatever another parallel may be. It also facilitates family sharing of purchases. It facilitates the generation of historic records of purchases. So there are a lot of elements of it that are part and parcel and really integrated into the operation of the App Store. And so it's far more than just one small administrative step. There's a lot of code and a lot of functionality, but it's all, again, fully integrated into the App Store and has really been there since the beginning.
So your expert opines that there's no separate demand for IAP. But as Mr. Bornstein correctly points out, once in that short period of time between when Fortnite was taken off the Apple platform and the dual functionality that had been placed on there by Fortnite was available, 50% of the people did in fact use the alternative mechanism. Doesn't that undercut, in fact, your argument that there is no demand?
No, Your Honor. What it seems to evidence is that when people can purchase V-Bucks for $7.99 instead of $9.99, evidence is that when people can purchase V-Bucks for $7.99 instead of $9.99, evidence is that when people can purchase
It's the last topic that we haven't really talked about in terms of the Section 1 and Section 2 arguments. Mr. Bornstein raised it. I don't know if you want to raise it or not. Mr. Doran, is the rule of reason analysis that Apple identified in its brief.
Your Honor, I think the distinctions that Mr. Bornstein draws in order to avoid the holdings in Microsoft and then the further discussion in Qualcomm of the need to do a deep fact analysis and therefore that the per se standard really has no place when dealing with the tech platforms. The fact that there are contract provisions involved as well as integrated technical elements, we don't think changes the analysis. I think, frankly, the fact that one would need to sort out between what is the nature of the product, how integrated is it physically into the platform, is it in fact only a contractual limitation, or is it also a technological single product? If one were dealing with what is clearly two separate products, there may be a discussion to have here, but here there's a threshold question of whether or not there's just a single product. We believe that's not even a question. As Your Honor noted, it's really a clever argument to dispute the 30%. So this is clearly a rule of reason situation. Having said that, we also think that with Rick Mick, it shows that it's a situation that is easily resolved in finding that this is a single product that therefore cannot form the legal basis of a tying claim.
Okay. All right, let's go ahead and shift to the other elements. This portion of the argument, Ms. Forrest and Mr. Boutros, will be much shorter. Unlike junior people, I don't feel so bad given that you all get lots of time in front of courts, and so you don't need additional argument time. I always feel bad when I have a young person who is given the last motion to argue in front of the court, and I'm out of gas and just say, no, I'm not going to hear argument, and I feel bad about it. But with you two, I don't feel that bad. I actually didn't read all that much new in the additional papers with respect to the remaining elements. So that's why I said I don't know that this part of the argument will be that long at all, given my admonition to you in the beginning not to repeat. But there were a couple of new things, but really not much. Ms. Forrest.
Thank you, Your Honor. What I'd like to do is to focus on a few things that we did not point out in our papers that are uncontested by Apple in its papers as to the irreparable harm that is real, that is actual, and that is happening today. And these are things which were set out in the declarations, the opening declarations of our witnesses, and they were not contested by the Apple witnesses. So I think that it's important to point these things out. One is that the iOS business for Epic has been shuttered. And that there are all kinds of statistics in Mr. Sweeney's declaration as to the declines. That is real, and that is happening. In addition to that, we have a shuttered series of businesses that are event businesses. These are the events that Epic puts on through the Fortnite app for concerts that we know the iOS users want. There were 2 million of them who attended the Travis Scott concert in April of 2020. We know that there is iOS demand for the other concerts and events in terms of ESPN exclusive performances, for the Discovery Channel exclusive performances, for the social justice conversations. Those businesses have been entirely shuttered for Epic. And 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 entirely shuttered. And entirely shuttered for Epic. And entirely shuttered for. And entirely shuttered for Epic. 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 And entirely shuttered. And entirely shuttered for Epic. 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 And entirely shuttered for. And entirely shuttered. And entirely shuttered for Epic. 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 And entirely shuttered for Epic.